Welcome to another Loud Little Ducky video. Owens loses another lawyer. Her attorneys that she had in her criminal case are withdrawn. So now she will have a public defender. I want to go over this and other updates and things that have happened in her criminal case. So let's jump in. First, we have filed on November 17th, 2025. In the Superior Court of Arizona, Maricopa County. Even though it was done on that, it was filed on the 19th. And it's the minute entry that says the court has received a camera request for Law and Crime Network. The court has considered the request good cause appearing. It is ordered granting that request for camera coverage for the complex case management conference set on 11/18/2025. Which we saw the coverage. It is new judicial officer is assigned to the case. A new camera request may be required. So Law and Crime can ask every single hearing if they can record the proceedings. 1, camera coverage must be done in accordance with Rule 122 of the Rules of the Arizona Supreme Court. This includes no camera coverage of any juror or attorney conference, any violation of the provisions of Rule 122, this order, or any directive given by the court may result in immediate termination of camera coverage in this case and an order to show cause hearing regarding the violation. No violations were done. 2, the camera must be set up at least 10 minutes before the proceeding is scheduled to begin. If the camera is not set up at least 10 minutes before the proceeding is scheduled to begin, the request for camera coverage for that proceeding will be considered abandoned and no camera will be allowed for that proceeding. This does not affect the camera request or related camera order for any future proceedings. So get up there, set your camera up, because we do not need this to be interfering with our court proceedings. 3, at any time, the court may order no camera coverage for specific individuals involved in the case, including but not limited to law enforcement officer, an informant, a victim, a minor witness, a party, or a witness if the camera coverage would have a substantial adverse impact on the witness. Well, we know Laura thinks that it does have a substantial adverse impact on her. Whether everybody else sees it that way is a different story. In the alternative, the court may order only audio coverage of certain testimony or that the face and identity be obscured. I don't care what we have. Do I prefer the camera version? Yes. If we could only have audio, I would take that too. So we're not having to rely on what other people see. 4, at any time, the court may order a restriction or cessation of coverage in the interest of justice. If this occurs, the camera shall be immediately turned off. We didn't have anything like that. There shall be only one pool camera in a fixed location. The location will be as directed by court staff. No additional lighting or flashes will be allowed, and only one microphone shall be used unless otherwise approved. So we understand that right now, one microphone is all that's allowed. So if this continues to be the only way things go is one microphone, the audio may be really hard for a bunch of us to hear. So keep that in mind when you're watching it and yelling at people to turn up the audio. With one microphone, it might be difficult. No camera or recording device shall be used while the judge is off the bench and until the case is called. No recording device shall record jurors, attorney conference, or content of documents at counsel table, the judge's bench, the work area of judicial staff, or the jury box. Any live broadcast shall have a 15-minute delay. So they weren't allowed to cover it live. It came out 15 minutes after, which the hearing was over before this was released. But at least we got to see it. and it is open to the public, which Laura hates, but that's in the Constitution. Next, we have that was written on November 18th, but filed on 11/19/2025, is the Complex Case Management Conference. And it states when it was at 9:09 a.m. Oh my God, 9 minutes late, guys. A recording of the proceeding is made digitally in lieu of a court reporter. Oh, so it was digitally recorded if there was no court reporter. Laura's going to have a field day with that one because she thinks everything should get canceled if there's no court reporter. It sucks when there's no court reporter. I don't know if there was one at all, but they said there's a recording of this in lieu of a court reporter. So maybe the recording is what stands for it, and that's the transcripts are going to have to go off the recording instead of a court reporter transcribing it. This is the time set for Complex Case Management Conference. The parties have filed a joint complex case management report. The court has received and reviewed the defense counsel's motion to withdraw submitted on November 17, 2025. There being good cause appearing. So the judge found that there was good cause to allow Edward Leiter and his Josh Coleslaw, whatever, to withdraw off the case. It is ordered granting defense counsel's motion and withdrawing Sandra Schultz as the attorney of record for all further proceedings in this matter. So Sandra Schultz has been the one that has been in court with Laura. She's the female that's always up there with her. We see Edward Leiter doing a lot of the written motions, and we don't really see Josh too much in this case other than the fact that it's his law firm. It is ordered granting defense counsel's motion and withdrawing Sandra Schultz as the attorney of record for all further proceedings in this matter, so they will no longer be on it. It is further ordered that the Office of Public Defense Services appoint counsel to represent defendant in this matter. So Laura will now have a public defender. Yay for Arizona taxpayers. It is ordered affirming the trial assignment date of January 22nd, 2026 at 9 a.m. before the master calendar assignment. The trial assignment hearing is in person for all lawyers and defendants. The parties should contact the trial assignment division prior to the trial assignment date to request to appear virtually. The purpose of the hearing is to set dates for 1, the trial procedure conference, and 2, jury selection date. So this is already saying that on January 22nd, they're going to be assigning dates. So the trial is not going to be happening on that time as of now. So it looks like it's already been pushed back to what we thought originally. And I believe it's going to be pushed back even further with these new indictments. But we have to wait till December 2nd to learn more about that. All self-represented litigants shall appear in person at the trial assignment date unless otherwise ordered. All in custody defendants shall be transported unless otherwise ordered. She's not in custody currently. Should the trial assignment judge approve a virtual appearance, the assignment judge's division will email parties instructions and a link to join the court connection video conference for more information. And then it lists everything. It is further ordered affirming the final trial management conference is going to be on January 15th, 2026 at 9 a.m. before that division. It is ordered setting a status conference for new counsel on December 2nd, 2025 at 9:10 before the division, and then joint case management reports no less than 2 working days before each case management conference. The parties shall file a joint case management report This report will inform the court of 1. Specific progress made since the last case management conference in completing activities previously established by the court and the parties. 2. Specific case preparations to be completed before the next case management conference. And 3. Witnesses who have been interviewed in the preceding month. Continuing on, 4 witnesses who will be interviewed in the upcoming month, 5 pending issues to be resolved. It is ordered that no time be excluded. Last day remains February 23rd, 2026. It is further ordered affirming prior release orders. Defendant is directed to appear at all scheduled conference hearings and advised of the potential consequence should he or she fail to appear. And then 9/12, the matter concludes. So that was kind of how things went down in that last conference that we saw. Or we're going to watch it here in a minute live, but that is everything that was discussed. I don't know that Laura Owens' side has interviewed or deposed or whatever any witnesses. They might have. I don't know how much money or how much work the attorney she just had did on this case. Or will her new attorneys have to pretty much do everything themselves? Because the last ones didn't do anything. Who knows? Or maybe they handled a lot of stuff in regards to the first 7, but then the second 7, that's going to be all new work for the new attorney because they withdrew off the case right as soon as those indictments came down, basically. So Kohlschrud Law, I cannot say that, law offices, filed on November 17th a motion to appear virtually, which she is going to put in this for every hearing, basically stating the same thing as to why he should not appear in person. Laura Owens, by and through undersigned counsel, respectfully requests this court to allow her to appeal virtually at the complex case management conference presently set for November 18th, 2025. Ms. Owens has been the subject of repeated online posts made by supporters of the alleged victim in this case. The postings and comments are generally very negative in nature and have caused Ms. Owens and her family concern about their safety. Why? Nobody has done anything to you. Nobody bothers you at these things. Nobody talks to you at these things. Nothing. Nobody has done anything to you. It's all in your heads. It's all y'all trying to play victim when you are not the victim. So it doesn't matter whether you appear virtually or in person. Things are going to be the same for you no matter which way you appear. People are going to talk about your case because it's of interest. And nobody bothers you personally. It's ridiculous. And the court, in my opinion, should tell her we have bailiffs and security on site for that. And shouldn't have any proof that anybody's done anything to her for her to have these fears. Due to the nature of the online postings immediately before the CPTC in this matter on August 11, 2025, defense counsel requested that additional security staff be present in the courtroom for the CPTC. Nobody bothers you, ma'am. What they have as court security is good enough because nobody talks to you. Nobody wants to have anything to do with you personally. We're just looking at your case because we think there should be justice for the men that you've caused harm to. Undersigned counsel believes that virtual appearance would be more practical in the interest of justice as it would reduce the need for additional security staff, prevent unnecessary disruptions, and ensure orderly proceedings. No disruptions are happening. Counsel for the state Edward Leiter has been contacted regarding this motion and has indicated that he takes no position. Yeah, Edward Leiter's like, do what you want, Judge. I don't care. I'm just putting in this file. This filing is just being put in because she wants it. Based on the foregoing, it is respectfully requested that Ms. Owens be allowed to appear virtually at the CCMMC scheduled for November 18th, 2025 at 9 a.m. They signed it and they e-filed it and all that. And they gave it to the proper people. Here is the hearing that happened, and it's just real quick. So
is CR 2025-006-831, State versus Laura Owens, time set for a complex case management conference. Can I get appearances, please?
Jennifer Lynn on behalf of Ed Leiter for the state, Your Honor.
Thank you.
Good morning, Your Honor. Sandra Schutz with Cold Root Law Offices on behalf of Laura Michelle Owens. She's out of custody and present, standing to my left.
All right. Ma'am, can I get your name and date of birth, please?
Laura Owens, 5/14/1990.
Okay, thanks. I did get the complex case management report, but then I also got Ms. Schutz's motion to withdraw. Ms. Owens, I know you wanted to appear here virtually, but now that the council issue came up, need you here in person to figure out what we're going to do moving forward. So what I'm going to do is I will grant that motion to withdraw. Ms. Owens, was your intention to hire another attorney, or how did you want to proceed?
Your Honor, I'm going to need to have a public defender.
Okay, so I did review a previously submitted financial affidavit and reviewed my previous determination regarding indigency, regarding appointments of experts. I'm just going to affirm that finding. I'm going to appoint the Office of Public Defense Services to represent Ms. Owens. Ms. Schutz, you're going to be relieved of any further obligations in this matter. What I'll do we have a availability next week for a status conference?
We're dark the whole week.
Well, that is Thanksgiving. How about the following week?
December 2nd at 9:10.
All right, so Ms. Owens, there's a little bit of administrative delay between my appointment and when they actually assign a lawyer. I'm going to set a status conference for December 2nd at 9:10. By that time, that administrative proceedings should have occurred. You'll have your new lawyer. They should be here to meet with you on that date, and we can discuss our future dates moving forward. There is a chance, though, since whatever lawyer gets appointed may not be available that day, that I might have to move that date slightly. So if you could give us your contact information, give that to my courtroom assistant. What we'll do is we will forward that to the attorney that is appointed to represent you, and also that way they can get in communication with you if you have to move that date. Got it? Okay, but December 2nd at 9 o'clock is the date you need to be here in person.
Okay.
If you don't show up, a warrant could issue for your arrest. All right, I think that's pretty much all we can do today, given the status of her attorney. Thank you. We are in recess in this matter.
Thank you.
Thank you.
Okay. So, just going to get the public defender. Right now, that's not on the docket of who it's going to be. And if you'll notice, if you look at the docket as well, it only lists the 7 charges right now. And that is because she has not been arraigned in court for the additional 7. She has been indicted, but she lost her lawyer at that same time. So at this December 2nd hearing, there should be a new attorney, and they should be able to kind of arraign her on these 7 charges, these 7 additional charges that she has. All right, and then there's a minute entry as well that was filed on November 19th, 2025. The court has received and reviewed the defendant's motion to appear virtually filed on 11/17/2025. That motion, there being a motion to withdraw pending, it is ordered denying the motion. That's why he wanted her there in person, not virtually, because she was going to be without representation. Then, this is something I don't know if I went over. I possibly did go over this, but I want to go over it again, because this is probably going to be her defenses for these next 7 as well. And this was filed July 10th, 2025. Notice of defenses and requests for notice of rebuttal witnesses. Defendant Laura Owens, by and through undersigned counsel, gives notice under Rule 15.2, Arizona Rules of Criminal Procedure, that any or all of the defenses listed infra may be raised at trial. Number 1, insufficiency of state's evidence. I don't think that that's lacking. State's evidence is very much sufficient. 2, general denial. Well, she can deny all she wants. The evidence says otherwise. 3, statutory defenses or exemptions. In support of any of the defenses, the defense may call the following witnesses at trial. Number 1, the defendant. In addition, the defendant may introduce at trial the following tangible objects. Yeah, I don't think you should call her as a witness. The defendant needs to keep her mouth shut because she only makes things worse for herself. So she is the only listed witness. And then they talk about this witness is going to, I guess, discuss or whatever the photographs of the alleged crime scene, diagrams of the alleged crime scene. 3, any object, thing, or document disclosed by the state or used to referred to by the state at trial. 4, any written or electronic record statements by any witness. Defendant reserves the right to supplement any of the lists above as additional information, evidence, witnesses, or any other relevant information becomes known. Defendant further notifies the state in accordance with Rule 15 of the Arizona Rules of Criminal Procedure that at this point in time, it is uncertain which witnesses will be testifying at trial or what the gist of their testimony will be. I wonder if they have a better understanding of that now, if that work was done. But we don't know that because they keep things hush-hush and don't go on a PR campaign online like other former attorneys. Further, it is uncertain which experts, if any, will be called at trial or what their testimony might be. You bring up an expert that sits here and says that she didn't do things that she's admitted to, that's not going to be good for their career. That's going to be laughable. Good luck with that. I don't think you're going to find expert witnesses in your client's favor. Likewise, it is uncertain what paper, documents, photographs, or other tangible objects might be used at trial. Well, you'll find that out if you haven't already. Also, pursuant to Rule 15.1F, Arizona Rules of Criminal Procedure, the defendant hereby requests disclosure of the names and addresses of all persons who will be called as witnesses in the state's case in chief or in rebuttal, together with their written or recorded statements, respectfully submitted on the 10th day of July by Owens, now former attorneys. So those are going to be her defenses. I think they're pretty lame, but she has lost another attorney. Her first attorney to lose in the criminal case. And we'll see who's next. I hope they're willing to do the work that they have to for Owens, because when she is found guilty, I don't want her to have any appealable issue. She can try to appeal like she always does, but there hasn't been anything for her to win an appeal on, and I don't want her to be able to win an appeal in this criminal case when she goes down for what she's done. Hit that like button, subscribe, turn those notification bells on so you never miss a video, and I will see you next time.